Please be seated. Veuillez vous s'asseoir.
Thank you very much and welcome back. Mr. Murphy, I know we rose 5 minutes to 11. Did you have more to add? Or I know that in all these submissions there would be, we do know that a lot of the questions posed of counsel that necessarily would not be enough to say all that everyone would like to say on them. But we'll just try and do our best with the time we have. And by the way, tomorrow, just so we know, the closing speeches, there'll be more time. I think we may have double the time already communicated, so that to allow council more time to say more. We will be indicating that from what we already published in the original timetable, we've adjusted the time to increase it for everybody. So we will then proceed along those lines. Now, one more thing I'd like to suggest by way of just a suggestion as we speak to this thing. I remember one of my old law professors in international law saying international law is law plus a large dose of common sense to it. So I would suggest that we, especially in this part that deals with consultation, and Mr. Murphy said, look, if there's any fault, it's not of our own making. Along those lines, are there any thoughts we may share, or you may share in your submissions as to how to improve the system, so we can take that into account to make the system work better? It will be welcome to share such thoughts. We all recognize that legal drafting is not a perfect art. It requires returning to things after we've worked them to see whether they could be improved. At least we can make suggestions to those who have the responsibility to improve them. The process of consultation in these things. Thank you. So then we will now go to the prosecutor. Good. Thank you.
Good afternoon, Your Honours. I'm Priya Narayanan for the prosecution, and I will now address you in some of the questions in Group C, and my colleague, Mr. Cross, will take over once I'm done. Now, specifically right up front, we'll note that the last question in Group C, which is question F, seems to be directed to the African Union, who speak after us. So, with your permission, we'll defer our response to that to when they actually speak. But let me turn now to the issues relevant to the referral of Jordan's non-compliance to the ASP and the Security Council. I will address question E, that's on any Article 97 consultations, before question D, relating more generally to the referral. And of course, we keep in mind, Your Honours, that common sense is key. But first, let me just make some very quick points on Mr. Murphy's submissions. Your Honours, a majority of the submissions have been briefed in writing, and we feel like we've written several hundred pages on it, but just some very key points. Just with respect to the prosecution submissions and the decision itself, we don't think that this is a question of a few lines or 4 lines or 1 paragraph, but one has to read it in context and in their totality. And specifically, and since that was referred to, prosecution filings 292 and 294, at no point did the prosecution say that there were valid or genuine Article 97 consultations. In fact, I think we've even used the word alleged. And the prosecution has always maintained across all these filings before the pretrial chamber and the appeals chamber that Jordan had an obligation and must arrest Mr. al-Bashir, that there were no legal impediments as such, and those obligations were not suspended by consultations or the request to consult. And similarly, Your Honours, on the decision as well, we don't think that one should focus on the ultimate finding. One, again, needs to read it in context, and including the very extensive chronology that the pretrial chamber included in its decision, and only some of which has been referred to. And my last brief point up front is on automatic referral. Now, again, Your Honours, much has been said about this, but as the party bringing the appeal in the Kenyatta case, we feel the need to clarify what the decision meant. What that decision stands for, and that's a response to one of the prosecution's arguments on appeal, is that there is no automatic compliance as a matter of law. It was a question of statutory interpretation there, not a question on the facts. And then we may ask, what does that mean on the facts? All that means is that the pretrial chamber should apply its mind to the separate question of the referral. And we can see that the pretrial chamber did just that from paragraphs 51 onwards of that decision. But let me turn now, Your Honours, to try to assist you on question E and question D. You ask in question E whether Jordan had taken any specific actions under Article 97 to consult with the court on purported difficulties they may have faced in executing the arrest warrant. The short answer is that Jordan took no meaningful actions relevant to Article 97. And this is because Jordan faced no genuine difficulty that required the court's intervention. Now, as the record shows, the only issue that stood in the way of Jordan's execution of the arrest warrant was Jordan's own decision and choice not to do so. And I believe, Judge Ibanez, you may have referred to this yesterday in one of your questions. Your Honours, there were no consultations in terms of Article 97. In fact, Jordan did not even communicate with the court until it was asked about the visit by the court's registry. And even when they were so prompted, Jordan responded with considerable delay on the 24th of March 2017, which was a mere 5 days before Mr. al-Bashir's visit to Amman on the 29th of March 2017. And when Jordan did finally communicate with the court, they did not express any difficulty in executing the arrest warrant. But to the contrary, they alluded to what was a précis of their ultimate position, not to arrest Mr. al-Bashir. This now should be on your screens, Your Honours. I believe on evidence 2. As you'll see, the relevant part of Jordan's 24th March 2017 note verbal said, quote, Jordan adheres to its international obligations, including the applicable rules of customary international law, while taking into account all its rights thereunder, unquote. And its response to this statement that the prosecution sought clarification, which of course subsequently the prosecution withdrew once it became clear what Jordan's position was. Jordan's first and only mention of Article 97 came very late in the day. And to be quite precise, it was on the 28th of March 2017, the day before the summit began. And the prosecution was itself officially notified of this document after working hours, somewhere close to midnight. Jordan's document, the one of the 28th of March, was limited to these few words, which I believe Mr. Murphy has already read out, but I'll do so anyway. Quote, Jordan is hereby consulting with the ICC under Article 97 of the Rome Statute of the International Criminal Court, Rome Statute, as regards the content of the arrest and surrender warrants, unquote. Your Honours, the remainder of that note verbal provided little more than an outline of the legal arguments that we've heard Jordan express in their written submissions and at the hearing today to defend their decision not to arrest Mr. al-Bashir. But quite simply, Jordan asked no question of the court. They identified no difficulty, no impediment to executing the request, and they relayed no uncertainty for the court to settle. Instead, it expressed a clear legal position supporting their resolve not to execute the court's request. And this, Your Honours, is the sum total of Jordan's interactions with the court before Mr. al-Bashir's visit to Amman in March 2017. Now, Your Honours, Jordan argues that since Mr. al-Bashir's immunity had not been waived, this in itself was the impediment preventing it from executing the court's request. But the court has made it amply clear that any such immunity claimed did not bar states from proceeding with its request. And it has said so not once, but multiple times. And it's no defense to argue that different pretrial chambers arrived at their conclusions differently. Your Honours, different judges are entitled to reason differently. And I believe, Judge Ibo Suji, you may have even remarked on, I think, what was the first day of the hearing, that this is hardly surprising. We agree. This happens routinely at courts the world over, and even at this court, when judges reason differently in concurring opinions, but they agree on the ultimate outcome. Now, if different judges within one chamber, the same chamber, can do this, why can't two different pretrial chambers of this court? Whatever the routes taken by pretrial chamber 1 and pretrial chamber 2, Your Honours, what matters is that all roads lead to Rome, and in this case, the Rome Statute. And they did. Every decision stated unambiguously that states parties were obliged to arrest and surrender Mr. al-Bashir to the court. And apart from Jordan, no other affected state has even appealed the outcome of these decisions, let alone challenge their reasoning. Article 97 is not meant for the purposes of expressing a contrary position of law at odds with the court's position at the 11th hour. If Jordan's interpretation of Article 97 is correct, then it would be open for any other state party to negotiate with the court on whether or not to execute its arrest warrants. Now, this is not to say that questions of law may not be raised as potential impediments under Article 97. But when they are, they should be those that require the court's genuine engagement and dialogue. And as my colleague Mr. Cross will say, a state's reading of Article 97 should also be consistent with its obligation to fully cooperate under Article 86. And in our view, any other reading, any different reading, would not be in line with the letter and spirit of Part 9 of the statute. Jordan's few interactions with the court raise no questions or difficulties that fit the Article 97 framework. And unlike Jordan's suggestion, which they've made in writing, for our purposes today, we do not have to consider if the consultation's procedure as such was unclear. The ASP's review of Article 97 is purely procedural. But on the other hand, the plain text, the statutory text of Article 97, obliges states parties, including Jordan, to consult without delay. This did not happen. Let me conclude on this question. Jordan did not consult with the court in terms of Article 97, nor did it make such a request. And even if Jordan had meant to launch an Article 97 consultation, why did it wait until the last minute? It was well known that Mr. al-Bashir was a possible attendee of the summit, which was held in March, and it was well known since January that year. Jordan had many opportunities to communicate with the court about the arrest warrant if it wished to. It could have done so in 2009 when it was notified of the arrest warrant, the first one, and in 2010 when it was notified of the second arrest warrant, and it could have equally done so any time in the intervening 8 years. And Your Honours, Jordan could have done so when it was a member of the Security Council in 2014 and 2015, when the prosecutor reported to that same council on the state of the law and the situation with South Africa, a situation which, in Jordan's view, raised very many similar issues. And Jordan was listening, since it endorsed that same prosecutor's report before the council. And I'd like to refer you, Your Honours, to the authorities in C3 on our list. And by some coincidence, and I hope I'm right, it may even be that our learned friend, Mr. Hmoud, was ably representing Jordan at that time in the Security Council. And Jordan could also have communicated with the court when it invited Mr. al-Bashir to the summit and when it was reminded of its obligation by the registry in February 2017. But it never did. And in these circumstances, the pretrial chamber correctly described Jordan's communications with the court as only providing an advance notification of its non-compliance. Your Honours, I'll move to question D now, on whether it's still desirable for the court to refer a non-compliant state under Article 87.7 when it is no longer... Yes, Your Honours.
Before you proceed with that, either you or Mr. Cross, whoever, can deal with the question to take it in stride, but do we have difficulty with scenario, with a certain dilemma? Is it possible that there is a dilemma that occurs in this way? A state party to whom a request for arrest and surrender has been made is looking at the request and saying, okay, it's thinking immunity, whether or not they're right, wrong or right about it doesn't really matter, but they're worried about immunity. And they're worried about, being held responsible for an internationally wrongful act if they transgressed immunity. And they come to the ICC and say, look, the way we are looking at this thing, we do see a problem of immunity. And the ICC say, never mind, go ahead and arrest. And then they say, well, when we get sued at the ICJ, you will not be there to defend us. So is it that clear cut for us to go ahead and arrest? If we have that kind of, do we see that problem here at all in good faith? And if we do, how do we deal with that? It may not be a matter of anybody's fault, but it could be a matter of drafting. I don't know, but think about it. Is there something to be said that whether it's such a legal question, you know, the issue is fraught with. There needs to be a process of quickly and rapidly resolving the legal question, perhaps to a definitive stage, before we engage responsibility for non-compliance.
Your Honor, I'll just very briefly say at this point, and you're right, we'll probably come back to it in the course of the discussion over the next day, but very briefly, we don't necessarily think that that's the issue that we're addressing quite right now because of Jordan's appeal, and we just think that it's a natural flow, Article 86, Article 97, and Article 87, and that's what the pretrial chamber's decision reflects. But of course, we will think of the bigger question and come back to you if we may. And Your Honors, on question D, yes, Your Honors, a referral under Article 87(7) would still be desirable and necessary in the circumstances when the immediate object of the compliance is no longer possible. A referral may not yield instant results, but it can reap long-term rewards. And I'd like to come back to your question, Your Honor, Judge Ibo Suji, about whether a referral is only meant for situations when there's a finding of bad faith. No, absolutely not, and we'd like to show that. There are very many other benefits of a referral to the ASP and the Security Council, and that's exactly why we have 87(7). Now, and I'd just like to make two key points on this. First, referrals under 87(7) can yield long-term rewards. And this was the case with Malawi. Following its referral to the ASP, the authorities of Malawi developed a dialogue with the president of the ASP, affirming that they did not intend to repeat their non-compliance. And these dialogues bore fruit. The government of Malawi declined to host Mr. al-Bashir at a subsequent African Union summit, leading even to the venue of that summit being changed. And similarly, following several other ASP initiatives, leading to discussions at the Human Rights Council, in the Universal Periodic Review, the DRC has now accepted recommendations to fully cooperate with the court. And as other reports of the ASP show, progress can be made through a variety of diplomatic and avenues and strategies. And I'd refer Your Honors to the authorities in C4 of our list. And we'd just like to note that in their submissions, Jordan did not address the value of an ASP referral. And no doubt, the Security Council is also well placed to foster further cooperation among states. And of course, in this respect, we note that when Jordan sought suspensive effect of the decision, the referral decision, it conceded that the Security Council may indeed take action. And regarding the Security Council, and responding to Jordan's submissions, it would be incorrect to rely on the pretrial chamber's statement in the South Africa decision in paragraph 138 to devalue the referral in this case. The decision to refer cannot depend on whether the Security Council meetings have yielded any tangible results so far. And to do so would be to put the cart before the horse. And here we also must note that within the Security Council itself, there are states such as New Zealand that have supported a reform of the response that the Council has to non-cooperation and non-compliance. And this has been supported by Sweden, Uruguay, Senegal, and France. But in any event, the Security Council's perceived inaction was not decisive in the decision not to refer South Africa. There were several other factors that the Chamber relied on, and crucially, due to South Africa's comprehensive national proceedings, the government accepted its obligation to cooperate with the court. This made the difference, Your Honors. And naturally, in such a case, we can say that the ASP and the Security Council need not be further engaged. But Jordan's case is obviously different. it has neither accepted its obligation to cooperate with the court, nor are there any national proceedings of any note. And turning to my second and final point.
Counsel has 5 more minutes.
Yes, thank you. We've said that Article 87.7 referral proceedings are not intended for any instant or quick fix solutions, and this is not also the benchmark against which such referrals are measured. One must take a long-term view, and this is why it's a judicial determination. A non-compliance proceeding, being a judicial one, requires the chambers of this court to hear the state concerned, as we're doing right now, and to make careful factual and legal determinations, as the ones that the pretrial chamber made in this case. The referral is also not an end in itself. It's only a means to the end. It's for the ASP as the guardian of the Rome Statute and the Security Council as the guardian of the specific situation referred to devise strategies tailored to each situation of non-compliance. So one can say it's inherent in these proceedings that they will take some time. And this, Your Honours, is precisely the judicial wisdom that has been reflected in every Article 87.7 referral decision that this court has taken, whether it concerns matters of execution of arrest warrants or otherwise, as we've seen in Kenya. And this brings me just to my conclusion on question D. Article 87.7 of the statute necessarily requires the court, and you, Your Honours, to take a long view. And there is wisdom in doing so. The court has no police force of its own, and it depends in a very significant way on state cooperation. Article 87.7 makes certain political and diplomatic remedies available to the court that otherwise may not be. And Article 87.7 is also the only statutory remedy in the face of non-compliance. Your Honours, it is our responsibility to strengthen it, not dilute it or simply delete it. Thank you very much. If there are a few minutes, I'd like to yield the floor to Mr. Cross, my colleague.
2.5 minutes. Exactly.
Thank you, Your Honours. I shall be very brief indeed, mindful of the time. I had hoped to address questions A, B, and C of Group C, but given the timing position we're in, perhaps I might defer that until those questions come up as they may in the question session after the break. And instead, I might just add one comment in light of Your Honour Judge Iboasuji's comment to my co-counsel, Ms. Narayanan. You asked whether states might be put in a, perhaps we even say, an impossible position as a consequence of the cooperation regime of this court. Very briefly, Your Honour, we would say no, and the safeguard for that is in Article 98.1. And we have tried to stress throughout these submissions that 98.1 says that the court will not proceed with requesting arrest where that obligation exists such that it puts the state in the position that you describe. There is a question, of course, as to the process by which the court, it might be right, it might ultimately prove to be wrong. But the safeguard is in 98.1 in the first place.
Are we not back in a loop of sorts?
Well, and I was coming to that. So the second half then, in terms of 97C as a matter of consultation, obviously 97C in its own terms comes after the request has already been issued, and that's in the plain wording of the provision. So we take it from that by the time you have the 97C consultation, the statute's premise is that 98.1, the court is already satisfied that there is no problem. Now, if the state comes along with, for example, reference to a treaty obligation, which perhaps was not known to the court, 97C in fact specifically refers to treaty obligations, then in that way we can see there is some space for a dialogue then between the requested state and the court, where the requested state brings this matter to the court's attention and says very respectfully, I'm sorry, Your Honours, there may be this fact of which you are unaware, there may be this practical difficulty, there may be something of the nature that wasn't part of the original decision. But for 98.1 itself, we would say if you don't have something new and you just say, I disagree with the decision, that's part of 98.1. And obviously I have to stop there. Thank you, Your Honours.
Thank you very much, Mr. Cross. So we will now move to the African Union.
Thank you very much, Your Honours.
You have 15 minutes?
We have how many minutes?
15 minutes.
15, sir. Thank you very much. We will be brief. I will give the floor over to Ambassador Negem in a few minutes to discuss the question that was specifically proposed to the African Union. Our intention is not to address all the issues, particularly the issues specific to Jordan. Our intention is to address the more general issues, and unfortunately that takes us back to some of the issues that have been raised in clusters A and B, but since the questions were asked, we thought we would address them. What I would say, though, on the issues relating to, I think, the main issues in this cluster, is simply to say that we fully share and endorse the arguments that have been made by Jordan. And in response to the prosecution, and in terms of the difference between the treatment of Jordan and South Africa, I would point out that as someone who had been involved in the South Africa case, in fact, South Africa did not make a commitment to further cooperate. The reaction was actually quite a negative reaction, but to start processes to withdraw. I just think that that ought to be on the table and sort of thinking about the difference in the treatment. So now I move directly to the question. And with respect to question B, it is correct that the duty to cooperate fully in Article 86 of the statute includes a duty to arrest and surrender. But by the express terms of Article 86, the duty to cooperate operates, and I quote, in accordance with the provisions of this statute, unquote. The provisions of this statute include, again, Article 98, and of course we have differences here about what precisely the implications of Article 98 would be. I pause here to mention that the very interesting and thoughtful arguments that have been advanced by the Office of the Prosecutor, Mr. Kress and others, concerning the implications of the fully, really apply to Sudan, really apply to Sudan in this instance, and has no effect in the relationship between Jordan and the Sudan. With respect to question C, the Chamber asks about the interaction between Article 86, Article 27, Paragraph 2, and then operative Paragraph 2 of UN Security Council Resolution 1593. All that we would point out here is that there's something very important missing. And again, for some reason, Article 98 is left out of that question, and yet it's a very integral part of the interaction. As we see it, the interaction would be as follows. So the interaction between these four sources, which would include Article 98. So Article 86 and Article 27.2, of course, address very different things. Article 86 concerns the relationship between the court and states parties, whereas Article 27 addresses something else. Article 27 relates to the relationship between and this is on its clear terms. We have had this discussion, but it's on its clear terms. It addresses the relationship between the court and the accused. No mention in Article 27.2 of the state, right? Of any state. So Article 86 then, in the context of arrest and surrender, addresses simply the possible ways that an accused could be brought before the court. But these possible ways, again, are subject to Article 98. Now, with respect to the role of operative Paragraph 2 of UN Security Council resolution, this, of course, will depend. With respect to Sudan, it is true, we accept, that the implications of operative Paragraph 2 would be that Sudan has to fully cooperate. But again, that imposes a duty on Sudan and nobody else, and does not affect the relationship between Sudan and Jordan, so that Sudan cannot use that as a justification for violating its obligations to respect the immunities of Sudan. As to its effect on other states, including Jordan, we would say the following. As a matter of law, operative paragraph 2 has no relationship whatsoever with Article 27. None whatsoever. As explained by Mr. Jallo in response to Group B questions, operative paragraph 2 leaves intact the Rome Statute rules, including, of course, Article 98. I note here that one of the legal theories that have been advanced by the Office of the Prosecutor and others is that the resolution places Sudan in a position analogous to states. I just want to point to something that hasn't been picked up yet. In the course of the oral pleadings, counsel for the appellant made a very compelling argument which hasn't been responded to. Hasn't been responded to by the applicants. No questions have been forthcoming. The very clear language of operative paragraph 1 refers this situation in Darfur to the court. It does not refer Sudan, it does not refer Darfur. Right? So I think, again, in sort of interpreting the impact of operative paragraph 2, it's important to note this particular provision. Now, one last point that I wish to make. Much has been made about the fact that Article 27, paragraph 2 refers to immunities under both national and international law. With respect, this is really, from our perspective, a non-issue. It ignores that a plain reading of the language in Article 27, paragraph 2 makes no reference to interstate relations or ICC state relations. It refers only to the accused, right? What it also forgets is that it is possible. We seem to be assuming that it's not possible for an accused to plead national immunities before the ICC. I don't know why that's not possible. That plea is unlikely to be successful, but it is possible. And it seems to me all of that, the only thing that that language does is to make it clear that if that's pleaded, that plea will be unsuccessful. Secondly, and I think this is even more important, it should not be forgotten that Article 21.3 of the Rome Statute does make it possible for national law to be pleaded and to be applied by the ICC. With these brief points, I now wish to hand over to Ambassador Negum.
Thank you, Your Honor. As described in our submission, the African Union has taken a number of decisions and policies to promote the fight against impunity. In this part, I would only tackle mainly the practice of the AU with regard to this case and others. This is evident in Article 4H of the African Union Constitutive Act. Moreover, although the Malabo Protocol is yet to enter into force, its adoption signifies the strong will of the Union to prosecute perpetrators of the most heinous crimes. Specifically, with respect to the current issue, the African Union established the high-level panel on Darfur in 2009, led by former President of South Africa, Thabo Mbeki. This panel made a number of recommendations directed at promoting accountability for atrocities in Darfur. The recommendations of the panel have been endorsed by the African Union Peace and Security Council at its 207th meeting held on 29th of October 2009 at the level of heads of states and government. Upon the adoption of the said recommendations, the African Union established the high-level implementation panel. The work of the panel proceeded as recently as 2017. Its members met with the government of Sudan to discuss the obstacles for challenges pertaining to the endorsed recommendations in order to facilitate their speedy implementation. Furthermore, we would like to reiterate that international regional organizations, including the African Union, usually incorporate in their host country agreements with states hosting their summits, meetings, and events a clause safeguarding immunities. This clause extends immunities to all participants in any meeting, including members of organization secretariat, representatives of member states, observers, and it goes without saying, heads of states and government. Your Honor, for the African Union, I just want to clarify how this process goes for us. Any state offering to host one of our meetings, the organization conclude a host country agreement for the specific event. This is a matter of practice. Host country agreements always contain the provision that the host state shall ensure the immunity of all participants to the meeting. This is a quotation we always have in our agreements, including the immunity from arrest or prosecution. This agreement, as executed by the international organization and the host country, constitutes an international agreement carrying obligations for each of the parties. The fact that this host country agreement is always entered into before a state is allowed to host a meeting of the international organization indicates that there is a state practice on the matter. In the case of the Organization of African Unity and the African Union, this has been an ongoing practice since the establishment of the organization in the 60s and has never been contested by any of our member states.
Council has 5 more minutes.
Good. I will finish before the 5 minutes. This fact and this provision with regard to the immunities has never been contested by any of our member states or any other state hosting our AU partnership meetings. Moreover, my office is the one concluding these agreements on behalf of the organization, and we don't debate that element. It's fundamental in our model, and we insist that it is not a privilege, but it is a right. And including it in our agreements is mere repetition to declare what customary international law stipulates in the matter. That said, it is the submission of the African Union that the mentioned activities, save in the potential context of complementarity, have no bearings on the current proceedings except the last part I have mentioned with regard to the immunities in order to bring it to the attention of your honors. I thank you.
Thank you very much, Ambassador. So we will now, in the absence of the representative of the Neva Arab state, we will now begin our round of submissions from the legal scholars. Before we do that, I need to post my question for the OTP to think about. In his reaction, Mr. Ladley said something in passing, but I'm not sure it's that small. He said that, in fact, South Africa did not cooperate, but they took a rather extremely antagonistic position of depositing notice of withdrawal. We need to address that in the sense that whether that is indeed what happened. If so, should they get credit for it while Jordan doesn't? That hasn't deposited such, it's taking that kind of approach. Thank you. Now, let's take the submissions from Mr. Kress.
Your Honors, in this intervention, I only wish to do 2 things. First, with your permission, I would like to briefly return to a very important point which had been left pending on Tuesday. It is related to Group C. Second, I wish to address 2 legal questions pertaining to the 1953 agreement in conjunction with the Pact of the League of Arab States. I would also be more than happy to offer to the Honorable Chamber a few observations on Article 87, paragraph 7 of the ICC statute, and on the 3rd ground of appeal. I will probably not be able to make it in this extremely brief amount of time of 10 minutes, but if the Chamber deems it to be of your help, I might use the 5 minutes question time to make these observations. Let me begin with the promised small addition to the important point which is still pending from our previous conversation. Our debate on the relevant customary law had made it abundantly clear how central one question is. The question whether the execution of a request by the ICC for arrest and surrender forms part either of the foreign criminal jurisdiction of the requested state party or of the international criminal jurisdiction. Jordan believes in the former alternative and understandably from its perspective keeps emphasizing the point in its interventions. The prosecution and I believe in the latter alternative. The point has been debated, and I shall of course not be wasting your Honor's time by rehearsing it. The one point which is pending is whether or not the ILC has taken a position on this point. And in view of the undeniable authority of the ILC, this is important to know. Earlier in our debate, I, and as I believe others as well, understood Mr. Murphy to say that the ILC has in fact taken the position Jordan prefers. I was surprised about this statement and have over the past 2 nights tried to review the ILC files with my humble means. The result is as follows. In her 6th report on immunity of state officials from foreign criminal jurisdiction of 12 June 2018, the special rapporteur in paragraph 43 addresses the point. This is an extremely interesting paragraph, but it is fairly long, and for reasons of time, I cannot read it out within my 10 minutes. I would be very happy to do it at any moment later if you allow me, but I want to refer very clearly the chamber to this paragraph. To me, this paragraph not at all sound like a position taken, let alone one in the sense Jordan prefers. Apart from that, the record seems to suggest that the debate about our point, the very specific point I have referred to, though having begun during the 2017 session, has not yet been completed. Your Honors, it is of course perfectly possible that I have overlooked evidence to the contrary. But in that case, I should be most grateful if Jordan could be kind enough to point that out to the chamber with specific references. Let me now turn to the 1953 agreement. I wish to make 2 points. First, this agreement, the 1953 agreement, does not fall under Article 98(2) of the statute. Second, this agreement can, and indeed it must, be interpreted in harmony with the customary International Criminal Court exception to immunity ratione personae. I begin with Article 98(2) of the ICC statute, and I respectfully submit again the 1953 agreement does not fall under this provision. As is well known, Article 98(2) has been one of the most controversial provisions of the statute during the negotiations and thereafter.
Councillor has 5 more minutes.
I mention this to signal that this provision must be approached with extreme caution. The 1953 agreement does not use the terms sending and receiving state, and does not establish to refer to a procedure for seeking and providing consent to surrender. More specifically, it does sound a little odd, doesn't it, to say that the state of Sudan sent President Bashir to Jordan. Sitting heads of states, it would seem to me, are the ones who sent lower-ranking officials rather than being sent. The ordinary wording of the proceeding does therefore speak against the inclusion of the agreement under Article 98.2. Now, Jordan criticizes such insistence on the wording as an, I quote, unsustainably restrictive reading. I agree with Jordan that a legal text should not be interpreted unsustainably restrictive. I only wish to add the call for consistency, and I invite Jordan to accept that also Article 27.2 of the statute and also paragraph 2 of the Security Council Resolution 1593 should not be interpreted, in Jordan's word, unsustainably restrictively. So I agree with Jordan on the point of method, that the analysis of the ordinary meaning of Article 98.2 of the ICC statute does not exhaust the matter. But what this analysis certainly does is to place a stringent burden on Jordan to demonstrate why the 1953 agreement, despite the serious difficulty with the wording, falls within the scope of Article 98.2. I fail to see that this burden has been discharged. Indeed, a contextual interpretation strongly supports the result the ordinary meaning suggests. Let me explain why. Jordan itself has been emphasizing throughout these proceedings that the relevant provision of the 1953 agreement deals with the question of immunities.
Pays.
Excuse me. My apologies, Mr. President. Immunity obligations are, however, addressed in paragraph 1 of Article 98. Jordan's proposed broad interpretation of Article 98.2, therefore, results in partial conflation and duplication within Article 98 and is therefore something which a sound contextual interpretation should certainly seek to avoid. I now wish to explain my second point, that the 1953 agreement should be read in parallel with customary international law. The reason for this is as follows. Article 14 of the Pact of the Arab League does not explicitly mention head of states. The key function of that article appears to be to provide certain other representatives of member states with certain privileges and immunities which they did not enjoy under customary international law. As heads of states already possessed immunities ratione personae under customary international law, there was no need to deal with them. If Article 14 is interpreted to cover them nonetheless, the content of the immunities remains to be defined by custom. According to its preamble, the 1953 agreement seeks to specify the immunities referred to in the Pact and to define clearly the manner of their application. This was again important with respect to those representatives who did not enjoy those immunities under customary international law. If Article 11 of this agreement is still read to cover heads of states, it is highly implausible that a new content of their immunities compared with the already existing customary standard was hereby introduced. It is equally highly implausible that the provision of a new conventional basis for head of state immunity meant that its content was from now on to be construed without regard to the development of customary international law governing head of state immunity. More in particular, it is highly implausible to assume that the conventional immunity protection for a head of state contained in Article 11 does not leave room for a harmonization with the customary international criminal law exception. For this exception serves nothing less than the effective enforcement of the jus puniendi of the international community through a permanent international criminal court. I would therefore respectfully submit that we are here confronted with a situation where customary international law, just this sentence, constitutes an essential guide to the correct interpretation of the treaty, a principle today reflected in Article 31.3c of the Vienna Convention of the Law of Treaties. Now would be the time to address the third ground of appeal, but I leave it to you whether I may.
We'll leave it there. We're out of time. Thank you very much. We'll next invite Ms. Latanzi.
Merci, Monsieur le Président, de me donner la parole sur les questions du groupe C. La disposition de l'article 98.2 représente elle aussi, comme celle de l'article 98.1, une exception à la juridiction de la Cour. Mais de la formulation de l'article 98.2 et de son histoire législative, il résulte clair qu'il ne rentre pas dans la catégorie des obligations considérées par les accords sous le 98.2. En fait, au sens de cette disposition, la Cour ne peut pas adresser à l'État hôte une demande d'arrestation et de remise d'une personne si cet État est obligé par un accord international à recevoir le consentement de l'État d'appartenance pour telle remise, à moins que la Cour même n'obtienne préalablement la coopération de cet État. Ces accords, qui en dérogation des critères de juridiction alternatifs accueillis dans le statut de Rome, le critère national et le critère territorial, portent par la prévision du consentement ad hoc de l'État national au cumul des deux critères. Ils ont le clair objectif de soustraire la personne accusée par la Cour et le relevant de l'État national à la juridiction de celle-ci, vu qu'ils posent l'exception à la juridiction de la Cour. En fait, ces accords n'envisagent pas l'application du principe de complémentarité qui comporterait que la personne soit obligatoirement soumise à la juridiction d'un des États impliqués, donc ou l'État requis, l'État territorial de la présence ou l'État national. Pour comprendre bien tant la ratio que l'intérêt qui se trouve à la base de l'exception à la juridiction de la Cour en raison de ces accords, je regrette, mais il faut se pencher sur le procès d'élaboration de la partie du statut, non seulement concernant spécifiquement la disposition de l'article 98.2, mais aussi les travaux préparatoires sur les critères de juridiction. Et la disposition de cet article de 98.2 naît en fait d'un intérêt des États-Unis, pays qui, tout en ayant donné une importante contribution à l'élaboration du statut, a toujours manifesté une certaine réserve à la création d'une Cour pénale internationale pour crainte qu'un de ses citoyens, mais surtout officiers, puisse être poursuivi devant cette juridiction. Cet État s'est donc battu pendant les travaux préparatoires pour faire passer l'acceptation dans le statut seulement du critère national. Et avant, c'était le critère national et territorial cumulé. Après, dans un esprit de compromis, c'était demandé, proposé par les États-Unis seulement le critère national. Après la défaite de ces deux tentatives et la victoire de la position des États like-minded, même si les like-minded ont perdu la bataille des 4 critères de juridiction. Mais donc, après la défaite des États-Unis en ce qui concerne ces propositions, ils ont commencé une campagne intense pour la conclusion d'accords bilatéraux avec nombreux États contenant la disposition sous-mentionnée. Les travaux préparatoires sur la disposition spécifique confirment donc la nature aussi de ces accords. Et pardonnez-moi de faire référence à cela, mais cela est aussi confirmé, l'interprétation de cette disposition, par la déclaration de M. Bolton d'hier. Donc la bataille des États-Unis continue pour exclure, soustraire ces officiers aux poursuites devant la Cour. Je suis sûre que la prise en considération de cette histoire législative, tant de la disposition spécifique, tant des critères de juridiction de la Cour, pourrait aider à comprendre que la Convention ne rentre pas dans cette disposition. D'ailleurs, comme le professeur Kress l'a déjà souligné, elle n'utilise pas du tout le langage de cela.
You have about 4 minutes left, 4.5 minutes.
Oh, sorry.
You have about 4.5 minutes.
4 minutes. Je voulais seulement m'arrêter un moment sur la question de la procédure. À propos de l'article 98.2. Elle fonctionne comme celle de l'article 98.1. Pour son interprétation, la Cour est le dominus exclusif. C'est elle qui va évaluer, avant de demander une arrestation, une remise par un État, la question d'un éventuel conflit d'obligations internationales pour ces États. Et donc, à quel État? À l'État qui n'est pas parti au statut ou qui n'a pas impliqué, qui n'est pas un État auquel la Cour a demandé l'arrestation d'un accusé et la remise de l'accusé parce que cet accusé serait impliqué, il y a le principe d'innocence, serait impliqué dans des crimes dans une situation renvoyée par le Conseil de sécurité. Ou un État qui est obligé aussi par le statut parce qu'il a accepté la juridiction ad hoc selon le 12, je ne me rappelle pas exactement la référence, le 12.3 peut-être, je ne me rappelle pas. Et donc, même à la lumière de cette disposition en cause, la Chambre préliminaire n'a commis aucune erreur de droit en adressant la demande d'arrestation et de remise de M. al-Bashir à la Jordanie. État partie, rappelons-le, qui est obligé par l'article 27.2 dans ses rapports avec le Soudan. État non parti, mais lui aussi obligé par l'article 27.2 sur la base de titres différents que la participation au statut. Merci.
Thank you very much. And I will take submissions from Mr. Newsman.
Thank you, Mr. President. May it please this court. These have been long and contentious and swirling issues. I wish to bring, in the light of our data, just some clarity to the issues. And I hadn't planned to do this so directly, but I would like to take up the President's offer to offer some prospective suggestions. And I'll do that in the end. The Polish delegate at the last 27th OTP report recommended that the Council adopt a persuasive course of action with the ultimate goal, which I think everybody in this room shares and Jordan shares and South Africa shares, of actually improving international peace and stability. That's the point. This has been the problem throughout, and the challenge that we face is how to use these legal instruments in a way that actually enhances regional peace and security. This is the statement from Costa Rica on the 5th of June, 2009. He said, "This council should not fool itself. The damage caused by the anti-juridical conduct of the government of Sudan is neither negligible nor limited to merely legal technicalities. This council, by its tolerant attitude towards that government, has contributed to eroding trust in international justice and has defended impunity." That's a pretty hard charge in 2009. And yet here we are in 2018 with these issues squarely presented, and the data shows, which is in the record and provided to the court, a number of trips that reflect disagreement over what the Costa Rica delegate dismissed as just legal technicalities. Going back to Judge Bosa's question, I think it's a relevant question. It's a very important question because it precisely framed the issues in a way that my good friend and colleague Klaus Kress just addressed very clearly. Are domestic states faced with these challenges, in fact, using their own internal domestic processes, which is what the statute says in Article 87 and Article 59, or are they acting essentially as agents for the international community? The problem here is, unlike the ICTY and the ICTR, that the statute does not require that domestic law always be fully displaced, nor does it require, in fact, it specifically contemplates that other treaty obligations and other obligations flowing from customary international law or treaty law are relevant. Mr. Cross alluded earlier to Article 97C, and he was exactly right. It talks about states who face pre-existing treaty obligations that prevent them, or in their view may prevent them. The challenge here is that the patterns of travel show that referral of itself can have some political impact. The example of Malawi in 2012 was given. There's exactly the right analogy and perfectly on point. But they can also have a perverse incentive. Travel to Chad is increased subsequent to referral and subsequent. So referral itself, as an act of this court, has a very unpredictable effect on actual travel. But what really matters to me, and I hope what matters to this court, and I hope what matters to the Security Council, a negligible effect on the rule of law inside Darfur and ending impunity. That's the challenge. In that spirit, let me offer 3 observations which we draw from the data in terms of Security Council debates. And the reason the totality of the travel is important, of course, is it reflects state practice, as I said. But at the same time, the travel, in one sense, reflects opinio juris of states and officials who say we have this right, and therefore my right to immunity must be respected. That's opinio juris on the part of those states. But the travel also generates opinio juris and statements of opinio juris. In the council debates that we have provided, you'll find the record is replete with examples, very concrete examples of reaction to these issues framed as opinio juris on the part of states. Let me give you 3 recommendations in terms of a referral, because 87.7 talks about, it just simply uses the word refer. It doesn't have any limitations as to the normative, practical content of a referral. It simply says when the states have acted contrary to the provisions of the statute. So that's the heart of the issue.
Council has 5 more minutes.
Oh, I thought I had like 2. Good. The heart of the issue is that there is disagreement in the international community, just as there's disagreement among the parties here, as to the precise interface of domestic law, which is absolutely embedded in the statute, and larger treaty obligations. That's the big reason why this court, built on the foundation of a treaty, is different from the ad hoc tribunals, because it is a treaty that operates in the context of other treaties, as envisioned by Article 97 Article 98.1, Article 98.2, et cetera. We all know that. The challenge is that within the international community, there is vehement disagreement over how to resolve that dispute. And I would just give you, as one example, there are many in the record. Here's the delegation from Malaysia on the 9th of June, 2016. It says, we reject any measure taken against African states on the pretext that these states do not respect or assume their responsibilities under the Rome Statute, or that they are not upholding Resolution 1593. We reject any measure against states that have not arrested or delivered President al-Bashir to the ICC, especially, and here's the opinion yours part, which is reflected in other statements, especially since African countries must respect their obligations stemming from resolutions and decisions of the African Union Summit, as well as the Constitutive Act of the African Union. My first of three recommendations for a referral, should this court proceed with a referral, and I hope that over time, this process serves to smooth out legal understandings, to incentivize compliance. In the first place, to the extent that a referral springs from a genuine disagreement over what acts constituted compliance with the statute or not, and their relationship with the Security Council, I think, in my opinion, based on the analysis of the data, is that a referral should specifically request the Security Council to take action, not in a generic way. It should frame the dispute over the actions of a state, that the state claims they've complied with their duties under international law. The court and the prosecutor feel differently. That's what a referral should do. Refer that issue to the Security Council for action, not as a generic end in and of itself. Number two, to the extent that noncompliance or lack of full cooperation is built on treaty conflicts, we've talked in this court about Article 103. The way to cut through that Gordian knot is using the power of Article 103 of the UN Charter, because, specifically, that will solve the problem. That will eliminate the treaty conflicts, set up a hierarchy, and so to the extent that there are treaty conflicts, again, the data shows that some states, perhaps acting in bad faith, other states acting in good faith, will use the rationale of a treaty conflict, which in some instances may be very well permitted under international law. In other instances, may not be. A referral, in my view, based on the data, should specifically request the Security Council to address those treaty conflicts. And third, to the extent that noncompliance is based on the application of domestic law, which is exactly what the statute envisions in Article 59, a request to the custodial state. It says it will be handled in accordance with the domestic law of the state. And we've talked before about the other provisions in Article 89 that do exactly the same thing under national law. This is the heart of the conflict that my friend Mr. Kress just mentioned. Again, the way to cut through that is with the explicit Chapter 7 authority of the Security Council, because, as was mentioned yesterday by Mr. O'Keefe, that's the legal authority, using the Security Council authority to legally, normatively impact matters which are essentially within the domestic jurisdiction of the state. In this instance, a conflict of their domestic provisions with their larger international law obligations. To my mind, that's what a referral should do, to try to move these issues forward, to try to incentivize compliance, to try to address this proliferation of travel. We very much appreciate, it's my last sentence, we very much appreciate the ability to make these presentations, but the data itself is very instructive. That's why we've taken such care to be as complete as we possibly could be and provide that to this court. Thank you.
Thank you very much. Now, Mr. O'Keefe.
Mr. President, Your Honours, I will focus solely on one aspect of question C, and I will attempt to do so without inadvertently insulting anyone, present, absent, living or dead. aspect of the question.
Try very hard.
Yes, exactly. That question is one we've touched on before, and I approached it from a different angle before, a logical angle. I'm going to approach it from an angle of interpretation now, which is how the general stipulation in Article 86 of the Rome Statute, that states parties shall cooperate fully with the court, or perhaps more to the point, how the specific stipulation in the second sentence of Article 89(1, that states parties shall comply with requests for arrest and surrender, should be understood in the light of Article 27(2 of the statute. My answer, as foreshadowed in my oral submissions on the questions in Group A, is no differently from how they should be understood on their face. That is, there is no relationship whatsoever between Article 86 and the second sentence of Article 89 on the one hand, which apply to the arrest and surrender of a person to the court by a state party, and Article 27(2, which applies to proceedings against a person before the court itself, only after that person has been arrested and surrendered to the court. Now, it is common ground that the starting point for the interpretation of Article 27(2 of the Rome Statute is the customary rules of treaty interpretation, supplemented by such uncodified canons of treaty interpretation as are generally accepted and applied by international courts, in particular the International Court of Justice. One of these canons is the maxim ut res magis valeat quam pereat, the principle of effectiveness, which dictates, as we've heard throughout these proceedings, that insofar as it is possible, an interpretation must not be adopted which would render redundant words found in a treaty provision. In the light of this maxim, it has been suggested by my friend Professor Robinson, and it's been implied in other questions, that an interpretation of Article 27(2 which would restrict its application to proceedings before the ICC itself and not lend it an application to national proceedings for the purpose of surrender of a person to the court would render redundant the words under national law found in Article 27(2. Professor Robinson argues that it is so obvious that immunities or special procedural rules which may attach to the official capacity of a person under national law could not possibly bar the court from exercising its jurisdiction over the person when that person is before the court itself, that it would be absurd to suppose that the drafters of the Rome Statute would think it necessary to state this. In effect, he says, and I know he has a good sense of humour and won't mind my putting it this way, any fool has heard of the Alabama claims principle, that national law is no defence to international law. Why would the drafters bother spelling this out? Mr. President, Your Honours, statutes of limitations are a phenomenon known to...
What about under international law? What is it saying? What is it doing there?
Well, Your Honour, there it's not allowing head of state immunity under international law. That I'm taking as read. Sure, absolutely. Thank you. I'm focusing on national law, sorry. Statutes of limitation. They're a phenomenon known to national law alone. There is no such thing under international law as a statute of limitations. No international legislature has ever enacted a statute of limitations because there is no international legislature. Nor does international law otherwise recognize a time bar to proceedings before an international criminal court. And yet we find it stated in Article 29 of the Rome Statute that the crimes within the jurisdiction of the court shall not be subject to any statute of limitations. Now, Article 29, like the surrounding provisions, apply to proceedings before the court itself. No state party, to my knowledge, interprets Article 29 to bar a state party under its own law and in its own courts from subjecting the crimes within the jurisdiction of the court to statutes of limitations. Indeed, many states parties do precisely this, at least when it comes to war crimes, and not infrequently also to crimes against humanity. In short, it is acknowledged by states parties that Article 29 applies only to proceedings before the ICC itself. Now, by parity of reasoning with immunities, it ought to have been so obvious to the drafters of the Rome Statute that a statute of limitations under national law posed
5
no
more
bar
minutes.
to proceedings before the court itself, that they would not have bothered to state this, and yet Article 29 makes it clear, for the avoidance of doubt, that an accused may not plead a national statute of limitations as a procedural bar to prosecution before the court itself, for the avoidance of doubt. In Sierra Leone, an amnesty was enacted in respect of certain crimes that also fell within the jurisdiction of the Special Court for Sierra Leone. This amnesty, like all amnesties, was a creature of national law alone, in this case, Sierra Leonean law. And yet we find it specified in Article 10 of the Statute of the Special Court for Sierra Leone that, quote, an amnesty granted to any person falling within the jurisdiction of the Special Court in respect of the crimes referred to in Articles 2 to 4 of the present statute shall not be a bar to prosecution, meaning prosecution before the court itself. This again ought to have been too obvious to specify. This again was specified for the avoidance of doubt. One reason why both Article 29 of the Rome Statute and Article 10 of the Statute for the Special Court for Sierra Leone specify what they specify for the avoidance of doubt is that the Alabama claims principle relies to reliance by states, not individuals, on substantive, not procedural, defense of the insufficiency or contrary prescription of national law. It is not obvious, with respect, what implications this rejection of a substantive defense to state responsibility might have to the procedural immunity and amenability of an individual to an international criminal jurisdiction in relation to individual criminal responsibility. As it is, I might add, the Alabama claims principle itself, in its substantive application to state responsibility, is apparently not so obvious that the drafters of Article 27 of the Vienna Convention on the Law of Treaties and Articles 3 and 32 of the Articles on Responsibility of States for Internationally Wrongful Acts did not think it advisable, for the avoidance of doubt, to spell out that national law provides no justification for failure to comply with an obligation under international law. In other words, even when it comes to a hallowed principle of international law, of which every undergraduate student of international law ought to be aware, it has nonetheless been considered judicious drafting to preempt a possible argument based on national law. The reality is that the statement in Article 27, 2, that immunities or special procedural rules, the latter being a reference to doctrines of non-justiciability, such as the procedural act of state doctrine found in the US, the UK, and many states of the Commonwealth, the non-justiciability of certain discretionary acts of a state's own executive branch, and so on, which may attach to the official capacity of a person under national law, shall not bar the court from exercising its jurisdiction, was inserted for the avoidance of doubt, so as to make it as clear as possible that the accused, sitting before the court itself, may not successfully avail themselves of the plea under the national law of their state, that the head of state or head of government or perhaps any other state official for the duration of their office enjoyed immunity from criminal jurisdiction, or under that national law that certain acts of the executive branch or certain acts of foreign states may not be questioned. So to quote the Court of Cassation of Belgium, as quoted in paragraph 7 of my written submissions, Article 27.2 does not affect the availability of immunity where a person is before the national courts of a state. As the memorandum of the UN Secretariat for the ILC says, it is generally recognized that Article 27 of the statute is to be interpreted as excluding the defense of immunity before the International Criminal Court alone. Indeed, states, to my knowledge, in their response to the memorandum of the Secretariat and to the ILC's work, have not said that it affects immunity from proceedings for arrest and surrender by a state party, and this is because it does not.
Thank you very much. Now, Mr. Roberts.
Thank you very much. I'm going to continue my tradition of restricting myself to fewer minutes than I'm allotted. I'm going to focus on 3 points, and I'm only going to take about 6 minutes. As you know, I'm representing a group of scholars, and our main message is that the pretrial chamber's analysis on the substantive law was exactly correct and should be affirmed. But as for the remedy, we think there's reasons in the circumstances why it's unnecessary to refer Jordan. And we think that the most helpful thing would simply be for the appeals chamber to clarify the law for states parties in the future. I have 1 point, actually it's now 2, thanks to the helpful thought by Roger O'Keefe on obligation to cooperate. I won't repeat the points I've made earlier because I feel like the bench has wonderfully understood our position. The council used the same technique it's used in the past. It ordered full cooperation with an instrument that removes immunity. And indeed, as Judge Bassa rightly pointed out, here it's even clearer because there's Article 27.2 removing any doubt about personal immunity. I just want to address one counter-argument that's been made by Jordan and the African Union. They point out, well, the ICC statute is different because the ICC statute has Article 98. And I just want to point out that Article 98 only matters where the third state has an immunity opposable to the ICC. It protects, Article 98 protects states whose immunities have not been relinquished. Sudan has lost its immunities. The Security Council has removed Sudan's immunities against ICC warrants. Now, importantly, again, I think we all seem to agree that Article 27.2 has horizontal effect between states parties. And I think it's the same thing. The obligation to cooperate fully equally applies to 1, states parties, 2, states who've made an Article 12.3 declaration, and above all, states who've had the obligation imposed on them under Chapter 7. The second thought is on statute of limitations. I thank Roger because I think he's wonderfully made exactly my point. He asked, why is the statute of limitations provision in the statute when it can't possibly be raised in the ICC courtroom? I think that's a fantastic point. Why is it there? It's there because Part 3 informs Part 9. It's there because a national court can't raise the statute of limitations during a surrender proceeding. So I think that's a wonderful point, and I thank him for that. Sorry, just to make sure you're connecting the dots. So therefore, just like Article 27, Article 29, all of Part 3 informs the entire statute, including the surrender proceedings. Second point, on the 1953 convention, I've already noted some options the last time I spoke. One possibility, the court might consider this argument Belgium made in an amicus that would preserve immunities for international organizations. A second one we suggested was that the chamber could indicate that there's space for a rule of procedure. But since the president asked about possible improvements to the consultation mechanism, I did have a favored recommendation that I didn't quite dare suggest, but I will at least float it to the bench in case you might consider it. You could take note that the states parties and the UN have showed a lot of concern about, quote, essential contacts. There's a recurring theme in a lot of resolutions. So it would, in my opinion, be open to the chamber if you're thinking about the consultation mechanism to say states could consult the court if they do so in a timely manner about what they see as an essential contact. I don't know if you would consider that too adventurous for the judicial role, but I just float that possibility to you. Finally, my third point, the referral of Jordan. I want to clarify something about our brief. Our brief was quoted by both the prosecution and by Jordan as saying that there's no violation to refer. I want to clarify that what we said was if, I want to underscore the word if 2 letters, but very important 2 letters. If the appeals chamber were to adopt this Belgian argument, then there would be no violation to refer. But that is a pretty big if in that context. However, even assuming that there were a violation, we do think there's reasons not to agree. I was convinced in response to question D, yes, of course, it can still be worthwhile to refer a state, even though the person has left their territory. So I think that's correct. But there are some circumstances here warranting restraint. Arguably, you could say, I think that there was an error of fact in law. 5 minutes? Yeah, sweet, great. Arguably, you could say there was an error of fact of law when the court said that Jordan had taken a clear position as if Jordan was being defiant, which is not necessarily the case. Arguably, there's an error of fact in law when the pretrial chamber said that they'd given an unequivocal message already to Jordan, because really the clarification of the South Africa decision came out later. And I think it would show judicious restraint to acknowledge that there's an intense controversy here, there's plausible criticisms, there was an aura of legal uncertainty, that arresting a foreign head of state is a momentous action. I myself worked for 10 years as a legal officer for a government, and we would want the most extreme legal clarity before we took such a step. So there are reasons to show sensitivity and the judicial virtue of restraint. And the remedy here from the chamber might just be to clarify the law for states parties for the future. Unless there's any questions, I'm finished there in 6 minutes.
Thank you very much. We still have some time to lunch break time. And now, in the absence of more speakers from the scholarly Michi, we will return to the prosecutor.
Your Honor, I apologize in advance, and if it's not too inconvenient, may we respond after the lunch break? It's just that this set of issues has thrown up a lot for us to think about, and to make best use of our 5 minutes, I think we'd probably need to consult a little bit. But only if of course, it suits you. Yeah.
We will take our lunch break now then, and
Thank you.
we come back at 3.
All rise.